You are listening to the Bail Post. On this episode of the Bail Post, we will be bringing you an update regarding an earlier episode that we had regarding the Daves versus Dallas County case. In episode 32, we talked about how the Fifth Circuit had reached or issued a very important opinion regarding this case and what its impact would be on this type of litigation. Today I'm going to update you about this case because it has gone through the appellate process. The plaintiffs filed a petition for certiorari at the United States Supreme Court, and in January of this year, the United States Supreme Court denied the petition for cert. I was holding off talking about this case because there was a companion case called the Little versus Doguet case, which was from Louisiana, which raised the same issue, or raised one of the two issues that was raised in Daves. And that case, the United States Supreme Court denied cert in the last week or so. So it's now time to bring you up to date regarding Daves versus Dallas County. Now, for those of you who may not have heard our previous episode, or not, if you've not seen any of the articles that I've written about the Daves case, this is a case that arose out of Dallas County regarding the way people were admitted to bail once they were arrested for a criminal charge. The Daves case was filed after a case called O'Donnell versus Harris County, where Judge Rosenthal in Houston ruled that county court judges, misdemeanor judges, could be sued in 1983 cases, even though judges normally cannot be sued. Her specific ruling was that when judges set up a bail schedule, when they were doing that, they were acting as policymakers for the county, and as a result of that action, they could be sued in a 1983 case. So that kind of set the stage for all the litigation that we've seen on these issues. And fast forward to the Daves case. The Daves case was filed in an attempt to extend the ruling that Judge Rosenthal made as to misdemeanor judges and to make it also apply to felony judges as well. The federal court in Dallas issued a preliminary injunction very similar to the one that was issued in O'Donnell versus Harris County, except for this injunction extended the ruling to felony judges as well. The issue went back up to the Fifth Circuit, and this time something unique happened. When you go to the Court of Appeals, your case is normally heard before a three-judge panel, and the three-judge panel ruled that they would follow the O'Donnell ruling as to misdemeanor judges, but they refused to extend the ruling as to district court judges and reversed in Daves on the grounds that district court judges were state actors and could not be sued in 1983 cases. The court also mentioned in their panel opinion that had they looked at the issue as a result of first impression instead of relying upon what O'Donnell said, they may have come to a different conclusion. As a result, a motion for rehearing en banc was filed in that case. And a motion for rehearing en banc is you're asking the full Fifth Circuit, all 16 approximate judges, to hear the case at once. This enables the court to reconsider previous rulings that were made by previous panels. And that's what happened. The Fifth Circuit en banc, in the first en banc opinion, reconsidered and reversed Judge Rosenthal's decision in O'Donnell. And they also held that misdemeanor judges could not be sued in 1983 cases. And they said that a misdemeanor judge, a county court judge, when they're setting bail, are state actors for the purposes of setting bail. Then the Fifth Circuit remanded the case back to the district court for a consideration of two issues. The first issue was younger abstention. And that is the issue of whether the trial court should have abstained, declined to address the case on the merits because there was adequate state court proceedings procedures to allow plaintiffs to raise those issues in the state court proceedings. I think part of the concept of that in this area is that the federal government doesn't want to micromanage ongoing state criminal court cases. I mean, we have a lot of case law that says the federal government should not micromanage ongoing state criminal proceedings. And so the case was remanded. The trial court on the two issues of whether the case was moot, that's the second issue, because in the interim, the Texas legislature had passed SB 6. So on the issue of abstention, the Fifth Circuit the trial court on remand said, we're not going to abstain. We don't believe abstention should be applied. But on the issue of mootness, the trial court, the federal court, ruled that the case was moot because the law had changed, and so that was no longer the law that was applicable anymore. And so the case went back to the Fifth Circuit, and the Fifth Circuit reversed the trial court on the abstention and said the trial court should have abstained, should have never even heard the case, and they went even further to say that both Daves and O'Donnell should have never been filed in federal court at all. And then they also agreed that the trial court, that the case was moot as a result of the legislature's passage of SB 6. So that is the issues that went to the U.S. Supreme Court were the issues of abstention and the issue of mootness. And that's what I consider those mostly procedural issues. If you were going to look at, okay, what's the likelihood that the Supreme Court of the United States is going to grant cert on something like that, you would say just in general the Supreme Court has, you probably have a 20% chance or less that they're going to grant your cert. But then when you add that the issue is procedural in nature, that probably takes it down even less. And so when we were when we were monitoring, or I guess when I was monitoring this case, one of the things I found out through research was that when they prepare cases to be considered by the U.S. Supreme Court, the clerks will look at the case and say, is this something that we need to have discussion about? Or is this something that we can just summarily all agree that this is an issue we want to consider? And so if the case is going to be put on the list that, hey, we want to discuss it, they will request a response from the other side. And that's what happened here. Before the case was set for conference for the judges to discuss whether they were going to accept the case, they requested a response from the county because the county hadn't filed a response to the petition for cert. And so so that was some indication that the case was being put on the list to discuss, that there were issues that the clerks thought that the judges should discuss. The ultimate day of the conference, there was a lot of different issues that were up for discussion that day. The Trump immunity case was discussed at the same conference, and I think there was an abortion case that was discussed at that same conference. And there were orders issued on Friday involving the Trump immunity issues, and then on Monday they issued all their orders, and the Daves case was one of the cases that they denied cert on. And then a month later, this month, in February, the Little versus Doguet case, they denied cert on it as well, just last week. And so I would now like to kind of talk about what is the legacy of the Daves versus Dallas County case. The first point I would make is I think Daves is an example of what happens when a plaintiff or plaintiff's attorney gets greedy. I mean, let's set the stage. The plaintiff's attorneys had won in O'Donnell. It was up on appeal. It got affirmed. The ruling that judges, as misdemeanor judges setting a bail schedule, were county policymakers and could be sued in 1983 cases. And so that ruling was affirmed. And so you had this litigation starting to be filed in numerous courts in Texas, especially. You had the Booth case in Galveston, you had the Daves case, and you had another case in Harris County filed. And so there was a lot of litigation going on, and I think the plaintiffs got greedy. Because if they had just focused and stayed focused on the misdemeanor cases, I think that there may have been a different result. I think what happened was when they started overreaching even more and trying to extend the rulings to felony cases, I think the judges had to stop and educate themselves on what was happening. And so I think there was a delay, just like in the cases that were being filed, where the attorneys representing the defendants were having to catch up and educate themselves on the law and on what these arguments that were being made by the plaintiffs. I think there was a lot of catch up being done, and I think that they got greedy, because the ruling that was made in the Fifth Circuit has actually, I think, will have a long-term ramification of stopping this type of litigation, especially in the Fifth Circuit and probably in other circuits as well. Because what the courts, the Fifth Circuit in en banc opinion said that if there's state court remedies or procedures available to raise these issues, then a federal court case should not and can't not be filed. They ruled, they were very direct that both Daves and O'Donnell should never have been filed in federal court. And you already see the ramifications of that, because in the Little case from Louisiana, that's what happened. Case was filed. The judge said, I'm abstaining. There's adequate procedures in the state for them to raise this. I'm following the Daves case, and I am just dismissing this on younger abstention arguments. But here's the problem. The problem is we have this group of plaintiffs' attorneys from civil rights courts that continues to file this litigation. I was recently on a debate with one of their representatives. They don't even acknowledge that they've lost the Daves versus Dallas County case. They don't recognize that they lost Calhoun. They don't recognize that they lost Sanchez. They don't recognize that they lost any case. They continue to make the same arguments that have now been rejected by courts. They still argue that bail is substantively unconstitutional, even though the 11th Circuit and the 5th Circuit have held that it is. They continue to argue that there's a violation of equal protection and a violation of due process, even though the 11th Circuit has rejected that argument. And so they keep making arguments and ignoring the fact that those very arguments have been rejected by the courts. Normally in a litigation, when you do something like that, you kind of get in trouble. I remember when I was in law school, I remember a case where Abraham Lincoln was being criticized by the United States Supreme Court because he took one side of an argument in one term, and then in the very next term, he came back to the United States Supreme Court and was arguing the opposite side of the same issue. When you argue the same issue and lose, when you argue an issue and lose, and then you come back and argue it again and ignore the fact that you've lost, I think there are some courts that would say that's sanctionable conduct. We're supposed to be, our responsibility as attorneys is we have to disclose the applicable law. What we're supposed to do is agree on the facts, agree on the law, but we argue about how the factual differences in the case and how it should be applied to the facts, how that is different. That's where the fight's supposed to be. But the fight with this group that are filing these cases is now, they don't agree to any facts. They won't agree, and they won't agree that they've lost the arguments, but they continue to present these same arguments. And so I would suggest that we have to consider, if they file new suits, especially in the Fifth Circuit, we should be looking for filing sanctions or looking for damages, because they are completely ignoring what the Fifth Circuit has ruled and what they ruled en banc. That's like the strongest opinion that they can issue, and that's a problem. And the fact that they're continuing to ignore it is even a bigger problem. The second legacy of the Daves versus Dallas County case is going to be around for a long time, and it's how do we address pretrial detention in the United States. when we first started seeing these cases being filed, we were told that we have to change what we're doing because the private surety bail system that's being used predominantly in Texas and in other states is unconstitutional. The courts have held that's the opposite. They've held that it is constitutional. The arguments are still being made, but now they're also adding to it is this element we have to have fairness. The problem is, okay, so how do we address pretrial release? We've got a lot of data now. There's different release mechanisms. There's the private surety bail system. There's simple release. Depending on where you are in Texas, it would be released on a personal bond. We have cash bonds. So if you were going to go on the priority, or if you were going to create a hierarchy of what's the best from getting people to court, the private surety bail system has the best track record of getting people to court by far. It's not even close. Cash bonds is not as good. It probably has a 50% higher failure to appear rate. And, it makes sense. Cash is being posted, but they're responsible for getting themselves to court. So, we have little problem children who have issues with being able to remember those things. And so I think it's just common sense that they're going to have a higher failure to appear rate. And then you have personal bonds, which have the highest failure to appear rate of any release mechanism in Texas. The equivalent in other states would, like in California, release on zero bail. In New York, release on no bond, which is same. Those are all the same thing. Simple release where you have you don't pay anything for the release. Okay, and so we've got those three release mechanisms, and they each come with a different failure to appear rate. And if you don't come to court, then your criminal case is put on hold until you come back, whether it's because you come back willingly or because you are caught committing another crime and they find a warrant for your arrest. And so, the different release mechanisms have higher failure to appear rates, which are going to create more and more backlogs. And we already have a huge backlog. And so if you want people to come to court, you want to encourage them to have more or use more surety bonds. There was a judge in East Texas who wrote an article that said, that she just did her own little thing in her court, and she found that for every 8 weeks of just using personal bonds, she created a whole new week's worth of work for herself, just based on the type of release she was using in her court. And so, while we have three different ways to release somebody, and we want to protect the poor, we have to recognize that the more that we use personal bonds, that they come with a cost of delay to the victim, delay to the system, and it can cause additional cases being added to your backlog. Where this becomes a huge problem is like what's going on in Harris County right now is we've taken away all accountability from personal bonds. So, the majority of Texas would find it just completely crazy that you could get 17 personal bonds, fail to appear 17 times in the same case, and you would just get another personal bond, and there would be no accountability. And the reason for that is because, the basic argument from our friends is that it's a misdemeanor. You can't hold them. They cannot be held. I mean, forget the argument about they violated a court order. They failed to show up for court. Forget about all that. Their argument is that they have an absolute right to release. And if they say they can't afford the bond, then you cannot hold them on a bond they cannot afford. Now, that argument has been rejected by the Fifth Circuit. I mean, the problem in the O'Donnell case and the problem in the Daves case was an argument of procedural due process. So the courts said if there was a problem, it was because they didn't have procedures to protect the poor because they were using bail schedules. And so the the poor person was told, you don't have an attorney, don't talk at the initial appearance, and anything you say can be used against you. So do not talk. And so they didn't have an opportunity to say, hey, I can't afford the bond that you just set according to the bail schedule. I need a lower bond. And so the problem is, without those procedures in place, what's the remedy? Judge Rosenthal in the O'Donnell case said the remedy was they had to be released. And in the Daves case, the trial court agreed. The problem is the Fifth Circuit has said that when you identify a procedural problem, then the remedy is procedural. And that's really the heart of the case when you're talking about the merits. Since you've identified a procedural problem, then your remedy is a procedural remedy. So it's not a right to release, it's a right to a hearing to ask for a deviation from the bond amount that was scheduled. And once you have that hearing, then the constitutional requirements have been met. That's the problem we're having right now in Harris County. Harris County has taken the position that they have an absolute right to release, and Harris County is not following Texas law right now for misdemeanors. SB 6 requires that a public safety report be done on anyone higher than a Class C before bail is set, and the magistrate has to review the public safety report before bail is set. But Harris County has this consent decree from O'Donnell where they entered into a settlement. The same O'Donnell case that has been reversed 2 or 3 or 4 times, 5 or 6 times, and where the Fifth Circuit ultimately held that it should have never been filed in district court. So Harris County has entered into a settlement. They've enacted a local rule 9.1 that says that unless you're charged with these 6 things, you get an automatic personal bond for $100. Well, along comes the legislature and passes a new bill that says you cannot release somebody or you cannot set their bail without reviewing the public safety report, the criminal history. That's not being done in Harris County. We know it's not being done. I've confirmed recently with my sources in Harris. It's still not being done. And in the meantime, there's a new case from the Texas Court of Criminal Appeals that says if the trial court sets bail or if the magistrate sets bail without reviewing the public safety report, that is error. So we have a systemic issue in Harris County where unless you're one of 6 or 7 charges for misdemeanors, you get automatically released on a $100 personal bond without reviewing the public safety report. And we now have a case from the Texas Court of Criminal Appeals that says if a court or magistrate does that, that is error. So we kind of are seeing where we are at odds. We have an election going on right now for the DA on one side, one political party side, where one candidate seems to be moderate and says, bail is, private surety bail is not the problem. If you want to see crime has gone up as the use of surety bail has gone down, and you see the other candidate saying, I will try to get rid of surety bondsmen. They're the problem. That's kind of been what's happened in the last several elections in Harris County. The elected officials blame the bonding community on the rising crime, and it seems to have been working. We'll continue to see if it works again. I think the third legacy of the Daves case is kind of a resurgence on this. Do we want to move to a system where we just release or detain defendants? It's kind of like the federal system. I've heard several people argue we need to move more to a release or detain system. But the problem is we don't have the capacity in Texas to have a release or detain system. Let me give you some examples about that. The federal government moved predominantly to a release or detain system in the mid-'80s. At the time the bill was passed before the reforms, approximately 25% of people arrested were detained waiting trial. After the reforms, currently, so after the reforms, passage of time, here we are in 2024, approximately 75% of people arrested in federal court are detained until they are tried. Can you imagine what would happen in Texas if we, in our urban areas, in our big cities, tried to detain 75% of the people who are arrested before trial and hold them? We don't have enough jail space. We can't do that. But more importantly is where we are right now after COVID and with not trying cases for years. Our jails are already overcrowded with very dangerous people. There's no capacity currently to have any accountability for misdemeanor charges in Harris County. I mean, one of the reasons why you see somebody released 17 times on a misdemeanor personal bond, even though they keep missing, is because they don't have anywhere to put them. I mean, they're already shipping large numbers of people to other jurisdictions, and their jail is full of very dangerous people. And then we just found out a couple days ago, that Harris County, the Houston Police Association, disclosed that there was over 200,000 cases that had been closed with the notation lack of personnel. So our city was telling us that crime was going down, and there was over 230,000 cases that were not investigated or completed because they just said we don't have the personnel. I don't buy that. I think they were using that to hide crime going up even worse than we thought it was. And this is bled over into other areas. It's we're going to give people accused of murder, we're going to release them, which never used to happen in Harris County. If you're accused of capital murder, you were just held until trial. And so we got into a period of time where we only held someone who was charged with capital murder after they were released and committed a second capital murder. People started referring to Harris County. You go to Harris County where you get one free murder before they're going to hold you. It's kind of like, the dog. You get one free bite before you're considered a dangerous animal. I mean, it's lunacy. But the problem is this mentality of, let's move to a release or detain system. There's people who are pushing for that for the very reason that we don't have the capacity to do that. They want to create chaos, because what does chaos do? Chaos creates backlogs. We can't have accountability in chaos. And then it puts pressure to, especially in the misdemeanor side, to dismiss cases. And once the cases are dismissed, well then, what do we have? We have de facto decriminalization. And I think we've got that going on to a large extent, especially in the misdemeanor area in Harris County and maybe some other counties as well, but it's growing into our felonies as well. Let's just go through the timeline, okay? They enacted these reforms and they did a settlement on the O'Donnell case. And so what happened next? Well, the district attorney issued a report saying that these new changes had increased the failure to appear rate by over 50%. That's misdemeanor court. Then a little bit later, the police association did a review of 1 week's dockets for all the misdemeanor courts and found at least a 75% failure to appear rate. And then Harris County Court Watch compiled 2 years worth of data using the same formula, and they found on average for 2 years an 80% failure to appear rate in misdemeanor court in Harris County. So what was Harris County's response? Well, they quit requiring people to show up for court. Yeah, you heard me right. So the response by Harris County was they quit requiring misdemeanor defendants to appear for court. So they started hiding. This is not the DA's office doing this. Is the trial courts are doing this. And so that's a problem. And then you think, okay, 80%, that's just got to be wrong. That's can't be correct. I mean, if you listen to one of our earlier podcasts we did with the district attorney from Yolo County, he said California's misdemeanor courts use a simple release mechanism for all defendants in misdemeanor court, and their failure to appear rate is 80% as well. So that's across the state of California. They can't get people to come to court. If they miss, they can't make them come because it's just a misdemeanor. And so today's misdemeanors become tomorrow's felonies because we don't have the room to create. We don't have capacity so that we can hold them accountable. If they don't come, we can't do anything with their case. That creates bigger backlogs. And it creates pressure to dismiss cases so that we don't have a total collapse of our criminal justice system. And that's going to be a legacy of the Daves versus Dallas County case and the O'Donnell case. Because we took a system that needed to be improved. Absolutely, we're always looking how to improve the system. But we took a system that was functioning and functioning well, and we completely destroyed it in Harris County. And here's the real problem. In Texas, the legislature considers the Harris County model for misdemeanors a complete failure. It's kind of driving Texas policy right now at the legislature. But at the same time, the people who advocated for those changes, they go to other states. They go to Ohio, and they go to the legislature, and they say, you should adopt for the state of Ohio the Harris County model. It's the gold standard. It works great. And here, they never point out, now, you need to know that the DA did a report saying it will increase your failures to appear by at least 50%. And by the way, the police officers union reviewed a week's worth of dockets and said a failure to appear rate of 75%. By the way, there's a Harris County Court Watch that reviewed 2 years worth of data and said on average the failure to appear rate is 80%. They don't say any of that. They say it's the gold standard. It's what you should switch to. And we advocate. So then Ohio comes to Texas and starts asking questions. And so we have to provide them with the real data of what's going on. Can't agree on facts. Can't agree on the law. It's kind of hard to find an area of common ground. The last legacy that I would mention in the Daves versus Dallas County case is who's really getting harmed as a result of this little trip we took, this circle of, hey, we have to reform it, we don't have any choice, oh, it's been reversed, oh, no, what we're doing is fine, no, we don't need any change. I'm going to make this statement. The very communities that these advocates say they're wanting to protect are the ones that are getting hit and hurt the worst. Let me give you a little data. 50% of all murder victims in the United States are young black males. By and large, they're being murdered by people of the same demographic. Somehow in this debate, we have raised the accused killer above the victim. The NAACP in Oakland in the last 6 months issued a letter to the local officials demanding a state of emergency on crime, saying what they're doing is wrong. The DA's response was, it's so sad that this great organization is using right-wing talking points, and we don't really have a crime problem. And the regional NAACP came out and said, no, we fully support the local NAACP problem, and we have a problem of crime. In the last month, the governor of California sent 75 additional California Highway Patrol officers to Oakland to help address the unmanageable crime problem going on. The problem that we have right now is we have people who are arguing you can't hold people, you can't they want to push a charge-based release mechanism system. So you don't ever look at their criminal history, you just look at what they're charged with. And if they're charged with a list of crimes, you have to just release them. But here's the problem. And I'll say these people had a good intention or some of them did. But here's the problem with that method. When you do that, organized crime, gangs, career criminals figure out ways to make money hand over fist. They make millions of dollars doing that. And that's what's happening. And when you tie the hands of judges so they can't do something in the name of protecting the poor, well, then they also can't do anything about those crime elements. And, really the unspoken, the area that, or the people that get hurt the worst that we don't talk about at all is domestic violence victims or survivors. Let's just call them survivors. Because even though we've amended the Constitution to say people who are accused of domestic violence can be held without bail, it's still a misdemeanor crime. And so for these people who consider any misdemeanor, you have no right to hold them, you have to release them, they get released. Caitlin Guajardo, she filed criminal charges against her husband, and he was already out on a personal bond for a different criminal charge. So when he was arrested, he was already in violation of his personal bond. And was he held accountable for that? No. He got another personal bond and was released and went home and killed his wife. Stabbed her 30-something times in the stomach. And Alex Guajardo said the reason why he did it is because he didn't want any other man raising his daughter or his child, because his wife was pregnant. The legislature, one of the bills that was filed that next session was called Caitlin's Law. And, you can hear one of the senators still mention the story of Caitlin Guajardo to this day. That bill did not pass, but the concepts of that bill were, or many of them were incorporated into the ultimate package that was passed as SB 6. How did we get to the point where we've set up a system of release that makes it so that domestic violence survivors no longer even take a chance of calling the police? Because it's now a race to hide before the defendant's released. When did we place the domestic violence defendant higher than the domestic violence survivor? We'll be feeling the ramifications of Daves versus Dallas County and O'Donnell for years to come, as we continue to straighten out these policy arguments that have really gone full circle. I mean, they've all been reversed. And I would just point out that in response to the Daves versus Dallas County decision by the U.S. Supreme Court, the Dallas Morning News printed an article, and they quoted one of the attorneys in Daves. And this was what they said. I'm paraphrasing. We're not ashamed to file in this case. Every trial court in the nation that's looked at these issues has held that bail is unconstitutional. What did they not say? Every court of appeals that reviewed the appeal of the trial court's case reversed. Calhoun versus Georgia, reversed. Even though one of the attorneys for this group was on YouTube belittling the arguments being made by the other side and saying they're just making fools of themselves. No, they ended up winning. Alabama versus Sanchez versus Alabama, reversed. A county had to live under a preliminary injunction where they could not have any accountability for 4 or 5 years. And then it was ultimately reversed. And I spoke to the sheriff, and he said, we re-implemented a system of accountability and consequences if you miss court. And it took about 6 months, and crime started going down. So we know what we need to do. Dave's reversed. If you go back to O'Donnell, the first O'Donnell appeal was reversed. And there was a stay issued of the second preliminary injunction where the Fifth Circuit said there's a high likelihood the judges will win. It's just then there was an election, new judges were elected, and the new judges said, we're just settling, we're giving the plaintiffs whatever they want. We've spent so much money, we spent $8 million defending this case, and so we just don't want to do it anymore. And so they settled and ended up spending over $100 million for this fiasco of a system that they now have for misdemeanor courts where they don't even require people to come to court because they don't want people to know that people will fail to appear. How do we fix this? How do we fix Harris County? I mean, it's going to take somebody going in, but it's not just filing a case and saying, hey, you're not following SB 6, and so let's have a court of appeals say you're not following SB 6, so you can't do what you're doing anymore. It's a bigger problem than that. Harris County has never done individual magistration for misdemeanors. Prior to O'Donnell, they used a bail schedule. It worked well. The problem they had is they weren't giving poor people an opportunity to ask for a deviation. Okay, it's easy to fix. The judges in the first case were willing to do that all the time, but the judge was giving the plaintiffs the ability to veto that. They wanted more. They wanted a substantive cure, and that's really what they ultimately agreed. They just gave them a right to release, which the courts have rejected. If the courts now come in and say you cannot have a $100 personal bond in a misdemeanor case without first reviewing the public safety report, which would require individual magistration, they don't have the capacity to do that. And so we've spent $100 million to implement a system which would not be functional if they were required to follow SB 6, which they are required to follow it. They're just not. And no one is calling them on that. So what happens? It will continue until someone steps in. I mean, you can see the beginnings of it. I mean, what's going on is not sustainable. You can't say crime is decreasing and then say, oh, by the way, we have 230-something thousand cases that we've kind of closed administratively, and we have victims. I mean, the news in Harris County is pretty bad right now because they're showing victims of those crimes that had their cases closed because they said they didn't have enough personnel. And so that's big news right now. So I have hope. I have hope for the future because what's going on is not sustainable. But the short term, we're going to have some growing pains. I think Dallas is doing a lot better because they've always opposed these changes. They've appealed the case. They were not willing to settle. So kudos to Dallas County. And actually, kudos for Dallas County for fixing the law that was initially handed down by Judge Rosenthal and O'Donnell and then affirmed by the Fifth Circuit before it was reversed. So the Dave's case is over now. I mean, it's completely done. Petition for cert denied. The Little case, which came after it, same thing, denied. So now we have to pick up the pieces of, Humpty Dumpty, his egg that was pushed off the wall by these groups, And let me just end by saying this. In the middle of the O'Donnell case, when the consent decree was being argued and, their settlement was being adopted and approved by the trial court, I met with, one of these attorneys representing the plaintiffs. And I told him, I said, you don't even know the damage you're doing to the criminal justice system. And long after you're gone and you've celebrated your victory and you've gone and given your speeches, we will be here along with law enforcement and anyone else willing to work to fix the problem, the broken system that you've created. And he looked at me like I was the dumbest person on the face of the planet. And here we are now. I mean, so many years later, and it looks like that's where we're at. The arguments that they've made have all been rejected. They've essentially been told they can't file another case in the in federal court in the Fifth Circuit. But right now, Harris County is not willing to fix the system. They're not willing to address it. They're just ignoring it. The politicians know it's not working, but they're not willing to change it because now it's become a very political issue. It can't continue. It won't continue for long. And when it does, when it comes to a head, it's going to be ugly. We've been through this before. In the 60s, we felt safe. We were more forgiving in our criminal laws. And as a result, we started seeing crime go up. Then we started talking about what we need to do to roll it back. And we couldn't agree. And we had people that said, I'm not going to agree with you on that. And so we ended up having the problem fester for a while, and then we had a backlash, and we had Reagan come into office with a strong on crime policy, with this 3 strikes you're out policy, and we're on track to do the exact same thing again if we're not careful. And so that will happen at some point unless our friends who are pushing these things don't slow down and don't acknowledge many things that they're doing are not working. If they would just put a level of accountability on there, like Hidalgo County, I talked to their sheriff, and one of the things he said is if you get a personal bond in Hidalgo County, if you're not successful on it, you will not get another personal bond. They don't have this whole thing of you're going to get 17 personal bonds. I mean, that's like a mockery of the court. I mean, would you like to be a judge of a case where there's 17 failures to appear and you just keep giving them the same thing over and over again? That's what's going on in Harris County. Thank you for joining us to talk about the Daves case and talk about its legacy. Things will not continue as they are. And I don't think the legislature will allow it. So we will see. Things could get worse before they get better, but eventually they'll get better because that case is over and we know what the law is now. We just got to get Harris County to start following it and we'll be better off. Thank you for listening and come back for the next episode of The Bell Post.